Madam Clerk, please open court.
The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina is now sitting for the dispatch of business. God save the state and this honorable court.
Good morning and welcome to these historic virtual arguments. This is the second day that the Supreme Court of North Carolina is hosting oral arguments virtually, and it is the second day in the court's 200th anniversary and its history. So we welcome you today. We welcome Mr. Mehta, Mr. Hill, and Ms. Shearer. The court calls the case of Crescent University City Venture LLC versus Trussway Manufacturing Incorporated et al. Mr. Mehta.
Thank you, Madam Chief Justice, and may it please the court, Kiran Mehta for Appellant Crescent University City Venture LLC. This case presents the issue of whether a designer/manufacturer of floor trusses, key structural components of any building, may avoid claims by the owner of a residential apartment complex that the trusses installed at the complex were negligently designed and negligently manufactured. Trussway, the designer/manufacturer in this case, seeks to avoid liability for its negligence on the basis of the economic loss rule. The Court of Appeals ruled in the Lord case, decided back in 2007, so more than 13 years ago, that a negligence claim in these very circumstances was not barred by the economic loss rule. Indeed, the Lord case dealt with defective trusses, and you can't get any more all fours on the facts than that. The business court, ignoring the Lord case as well as other controlling appellate decisions, held that the economic loss rule does indeed bar the building owner's negligence claim. In so holding, the business court arrogated to itself the power to overturn controlling adverse precedent. The business court was wrong to do so and therefore must be reversed. The relevant facts here are very straightforward. The case was decided upon Trussway's motion for summary judgment, so all facts are presented in the light most favorable to Crescent. Crescent entered into a general contract with AP Atlantic to construct the apartment complex in December 2012, so more than 5 years after the Lord decision was rendered by the Court of Appeals. AP Atlantic, in turn, entered into a subcontract with a framing contractor, Madison, for the procurement and installation of the floor trusses. Madison, in turn, entered into a contract with Trussway for the design and manufacture of the trusses to be installed at the project. The trusses proved to be defective, and Crescent spent millions of dollars to repair the defects and incurred millions of dollars in additional damages resulting from the situation. There is no question but that Crescent presented a forecast of evidence showing that Trussway was negligent in the design and manufacture of the trusses, and that negligence was a proximate cause of its damages. Crescent's structural engineering. You have a question, Justice Ervin? Oh, sorry. Crescent's structural engineering experts presented reports indicating that Trussway had failed to comply with the applicable standard of care and testified at deposition as to Trussway's negligence and Crescent's resulting proximate loss. Excerpts from those depositions are set out in our briefing. And there is no question but that Trussway both designed and manufactured the trusses. Its engineers sealed the design drawings for the trusses as required by its contract with Madison, and the trusses were manufactured at its facilities. Now, on appeal, Trussway seeks to downplay its role as the designer by pointing to allegations made against the project engineer and the project architect, both of which were retained by Crescent. And I'm referring specifically to footnote 10 in Trussway's brief. Trussway fails to note, however, that those allegations were made by AP Atlantic, not Crescent. And at least with respect to the trusses, Crescent specifically denied that its engineer and architect were the designers, but rather that Trussway was the
Mr. Mehta, is the fact that, at least as you contend it, the record shows that there was a design function performed by Trussway. Is that a material fact here?
Yes, Your Honor. It's certainly a material fact based on the case law that Judge Bledsoe, the business court judge who decided this case, essentially ignored and in fact cited to contrary case law from other jurisdictions.
Let's say hypothetically that Trussway had been nothing more than a manufacturer. Would your argument be different? Would the outcome be different?
The outcome would not be different. We would just not be arguing about the design function of the trusses as opposed to.
So under your interpretation of the relevant decisions, a mere manufacturer, if there is such a thing, would be just as liable as a designer manufacturer?
Certainly in the context of a product like trusses, which have obvious life safety implications and certainly are key structural components of any building. And so for that reason, Your Honor, that distinction strengthens our case, but it is certainly not dispositive of our case.
Mr. Meadow, let's go back to basic principles. If we start with Port's authority, are you claiming that this case falls within one of the existing exceptions, or are you asking us to recognize a new exception, or are you claiming the economic loss rule doesn't apply at all?
The third option, Justice Davis. Port's authority does not control this case, much as Trussway would like for it to control this case. In fact, the thrust of its argument is that this court's decision actually does control. And the way you can tell that Trussway is wrong about that is just to see the lineup of the parties in Port's authority and the lineup of the parties in this case. Both cases have a project owner. The NC Port's Authority in the Port's Authority case and Crescent in this case. Both cases have a general contractor, Dickerson in Port's Authority and AP Atlantic in this case. Both cases have an installation subcontractor, Scott, the roofing subcontractor in Port's Authority, and Madison, the framing subcontractor in this case. And both cases have a manufacturer or material supplier, Fry, the manufacturer of the roofing membranes that failed in Port's Authority, and Trussway, the manufacturer of the trusses that failed in this case. Port's Authority dealt with the relations between and among the owner, the general contractor, and the installation subcontractor, and the claims brought by the owner against both of them. It specifically did not deal with the owner's claim that the manufacturer, which in any event was not in negligence but on a guarantee bond. The court noted, and I'm looking at page 7576 of 294 NC, that the present appeal has no relation to plaintiff's alleged cause of action against Fry on the bond. So Port's Authority, Your Honor, does not control this case at all, and it certainly does not stand for the proposition that a building owner's claim for negligence against a truss designer or manufacturer is barred by the economic loss rule, because that issue was not even in the case and not addressed by the court.
I want to make sure I understand why you're contending the economic loss rule does not apply. Is your argument that it doesn't apply solely because there was no contractual privity between Crescent and Trussway?
That is the basis of the Lord case, Your Honor, and certainly
which we're not bound by, of course.
That is true. But it's been around for 13 plus years.
But again, just so we're clear, if there was a contractual relationship between Crescent and Trussway, would you still be making this argument?
Absolutely not. If
Well,
it was,
in Ports Authority, there was also a claim that, asserted by the building owner against, as you know, against the subcontractor, and we held that that was likewise barred by the economic loss rule, even though there was no privity there, right?
that is correct, Your Honor.
So why is this any different?
Because, Your Honor, that subcontractor was like Madison, an installation subcontractor. It had no function whatsoever in the design and manufacture of the product that failed. And that is the distinction between that subcontractor and and our case, Justice Irvin.
So again, just to make sure I'm understanding the answer that you just gave to Justice Davis, it is then critical that Trussway is a design/manufacturer rather than a framer?
Sir, Your Honor, we did not sue the framer in negligence.
Why would it make any difference between? Why would there be a different standard of liability for a framer on the one hand and a designer/manufacturer on the other?
I think the answer to that question, Your Honor, really goes to the claim that was actually made by the roofing subcontractor, and if you want to analogize, could have been made and was not made against the framing subcontractor in our case.
Let's assume hypothetically that your claim was against Madison in this case, and you alleged that they negligently performed their framing work. Would you have a negligence claim against them?
That would be precisely the claim that was asserted against the roofing trade contractor, subcontractor in Ports Authority, and we would not have that claim.
What would be a principal distinction between a claim against a framer and a claim against a manufacturer/designer?
I think that comes back to the basis of the Lord case, which was not decided. Judge Wynn didn't decide that one in a vacuum. He also decided it in the context of a case from this court, Oates. And what Judge Wynn said in Lord, quoting Oates, was the duty owed by a defendant, and I'm quoting from 182 North Carolina Court of Appeals reporter, I believe it's around 640, 641 in that range. But the duty owed by a defendant to a plaintiff may have sprung from a contractual promise to another. However, the duty sued on in a negligence action is not the contractual promise, but the duty to use reasonable care in affirmatively performing that promise. The duty exists independent of the contract. Whether a defendant's duty to use reasonable care extends to a plaintiff not a party to the contract is determined by whether that plaintiff and defendant are in a relationship in which the defendant has a duty imposed by law to avoid harm to the plaintiff. And that setting, Your Honor, in Oates, which Judge Wynn followed and the Court of Appeals panel followed in Lord, is precisely the same setting as the Davidson and Jones Schaffner Industries line of cases that dealt with design professionals. And so you can see that certainly in the context of a manufactured product, and certainly a product like trusses, which have the structural component and the life safety components to them, the issue there really deals with, is there, just like in Davidson and Jones, just like in that whole line of cases, just like in Lord, just like in Oates, was this relationship among the parties one to which the negligence principles would apply. And the answer to that is yes, because negligence principles are the principles that provide that a product manufacturer designer such as Trussway owes those duties to people up the chain from its particular niche in the construction project.
Well, Councilman Tort did look at the Oaks case and said that the duty of care was appropriate to recognize there because there were latent defects that would affect home buyers. Wouldn't that be different from the situation in the present case in terms of talking about any such breach of duty, where in this case you're talking about students that would be renters on a shorter term basis, as opposed to in Oaks, where the court recognized a duty of care for latent defects for subsequent home buyers?
Well, first, Your Honor, these defects are clearly latent. They by the time they were discovered, they had been covered up by sheetrock and things of that nature that made them not possible to see prior to the time that they were discovered.
But the investment by a student renting would be different from a home buyer who would be in it for a longer duration of time, presumably in its ownership.
Well, Your Honor, it is true that Judge Bledsoe made that distinction. He made it both with respect to the Lord case and the Oates case. And essentially saying that there was a disparity in the parties' relative sophistication and bargaining power. But there are really immense problems with that approach. For example, would the holding apply in a case of a highly sophisticated homeowner, or at least one that has access to sophisticated counsel and advice? For example, Your Honor, what if Michael Jordan built a vacation house up in the North Carolina mountains and the trusses failed? Would he not have a claim in negligence while the mom and pop homeowner plaintiff would have a claim in negligence? Or look at it in a different way. If instead of mom and pop homeowner building a house, what about mom and pop Inc. building a small retail store? If the trusses fail, would they not have a claim in negligence against the truss manufacturer with respect to the store, even though they would have had that kind of a claim if the trusses failed at their house?
Are there any limits to your argument? Under your argument, are there any restraints on a building owner ever being able to sue a subcontractor for negligence when a building construction project goes bad?
Well, there still would be the Ports Authority limits against essentially a service provider. That's not an issue in this case. So those limits would still apply. In terms of the type of party that Trussway stands in, that is the product designer, manufacturer who then sells to the installer, the limit really.
So, Mr. Miller, I hate to be dense, but is a little more dense than I usually am. But is the distinction that you're asking us to draw between an entity that, on the one hand, between an entity that performs a pure service function as compared to an entity that performs a manufacture/design function?
I think that distinction is drawn in the cases, Your Honor, and that is why the design function service provider actually is liable in negligence to parties with whom it does not have a contractual relationship. That's the Davidson and Jones case.
So again, any building owner, regardless of its degree of sophistication, would have a negligence-based claim against some types of subcontractors, but not others?
I think that is the conclusion that you have to draw, and Judge Bledsoe declined to draw from. And so
why is let's get out of parsing cases a second and try to look at it more broadly so that simpletons like me can understand it. Assuming, given that we've got the situation that we've got in the cases, given that this is essentially a common law doctrine, why would it make sense to rest the line between, on the one hand, on the basis of a test that rests upon the functions performed by various subcontractors, which is what I understand you to be arguing, as compared to a test that focuses upon the overall nature and complexity of the project in question, which is the way that I read Judge Bledsoe's order in this case.
Your Honor, I think it really comes down to a couple of points. First of all, Lord has been the law in North Carolina for over 13 years, and none of the alleged ills that proponents of the economic loss rule in this context have been evident in North Carolina. So I think the message there is you got to be a little bit wary as judges of purported policy-based rationales that may or may not have real-world consequences. Then beyond that, Your Honor, again, Lord is part of the framework of the law that forms the backdrop to these particular relationships. Over 5 years after Lord was decided, this contract was entered into, and the law at that time in North Carolina was clear that a truss manufacturer could be sued in negligence by the building owner. If the theory of the economic loss rule is to give expression to the expectations of the parties, the expectation of the parties at the inception of this project was framed by that legal backdrop. Trussway had an out because the out, and this really goes back to Justice Davis's question in terms of where are the limits. The out was that if it had presented a warranty that ran all the way up to the building owner, then there's no question, and the cases are completely unanimous on this point, that the economic loss rule would have barred a claim in negligence because the claim would have been a contractual rights claim based on the warranty. And if you go all the way back to Ports Authority, that was the claim that was asserted by Ports Authority against the manufacturer of the roofing membrane. It was called a guarantee, but essentially it was a product warranty claim.
Other than economic losses, what kinds of losses has Crescent suffered that would render the economic loss rule inapplicable and support the tort claim of negligence?
Well, there are a number of consequential losses that occurred as a result of the failure of the trusses. They include costs related to moving students in and out of the apartments, costs related to ensuring that the students were taken care of and had housing and storage for their stuff during the time that the repairs were being made. And in addition to that, costs incurred by Crescent itself in terms of lost opportunities while it was mucking around with all of those repairs and things of that nature.
Aren't those measurable economically, all three of those that you just mentioned?
They are all economically measurable, correct. There is no...
So how is the economic loss rule not applicable then to capture the tort claim of negligence if you say the economic loss rule doesn't apply here?
Well, the economic loss rule doesn't apply here under the Lord line of cases because there is no contractual privity and because there is no warranty that extends all the way up to Crescent. And that's why the economic loss rule does not apply. We're not asking for an additional exception to the economic loss rule, as Trussway suggests that we are.
Mr. Mehta,
we're saying.
Is there any difference between the duties that trustmen owed under a negligence theory as opposed to the duties they were bound to perform under their contract? I
think in terms of what Trussway was obligated to do, the answer to that is that the duties were somewhat congruent. But the issue there is, to whom were the duties owed? Under their contract, their duties were owed to their contracting party, Madison, and nobody else. Under a negligence theory, their duties would be owed to parties that have some relationship to the problems that are caused by their failure to carry out and meet their standard of care. And those parties necessarily include the owner of the building in which the defective trusses are installed.
Well, in terms of a remedy, as I understand it, you have existing claims against AP Atlantic. Don't those claims encompass the alleged failure of Trussway to properly perform its duties under the contract?
Absolutely. There is a contract claim against AP Atlantic.
So from a broad perspective, from a remedy perspective, why isn't that enough of a remedy for your client?
Because, Your Honor, any contract claim is bound by the confines of the contract, whatever they are. The damages in this case are much broader than those contract damages, or at least the recoverable contract damages. But those damages are recoverable through a negligence claim, through a negligence cause of action. And therefore, under Lord and under the cases that follow Lord, including Hospira, which dealt with sophisticated parties.
Case. I'm trying to understand what aspect of damages that you claim you suffered as a result of Trussway's negligent performance of its contract. What categories of those damages would you not be able to recover in your suit against AP Atlantic?
The business court ruled in enforcing a consequential damage clause in the AP Atlantic Crescent contract that a number of the categories of damages were not recoverable. They've dealt mainly with dealing with moving students in and out of the housing project because of the need to move them out in order to perform the repairs. The additional categories of damage that were not even sought against AP Atlantic are the types of lost opportunity type damages, payment of additional interest on construction or on permanent lending loans that resulted from delays in the disposition of the project, things of those types that are available in under a negligence claim, but are not or were not available under this contract claim.
And my last question is, couldn't this contract have been written in a way that expressly provided for a contractual remedy between Crescent and Trussway?
Well, the answer there, Your Honor, is which party is the one best suited to make that provision? The party best suited to make that provision is the manufacturer of the product, because the manufacturer of the product can issue a warranty, just like all the warranties that window manufacturers and siding manufacturers and the roof membrane manufacturer in Ports Authority made, that extend all the way up the chain to the ultimate owner of the project and subsequent owners of the project. Trussway did not do that in this case. It could easily have done that in this case. It chose not to do that in this case.
But isn't it true that your client had the opportunity to reject any of the subcontracts that were deficient in any manner, including those that didn't supply the type of warranties that you're talking about?
Your Honor, the contract in that construct, yes, the contract does say that. But again, legal relationships. The backdrop of the legal relationships is there is a claim in negligence against the truss manufacturer because Lord says so. And as a result, the party best suited to make a change in those backdrop legal relationships is the one most directly affected by them, which would be Trussway.
Doesn't the Lord case specifically say it relies on our case, actually quotes extensively our case from Oates? And didn't Oates as well as Lord both have to do with consumers as opposed to commercial contexts?
It does rely on oats, and both of them were in the consumer context. But, Your Honor, then we go back to the Michael Jordan example, the Mom and Pop Inc. example that I was discussing with, can't remember whether it was Justice Morgan or Justice Davis, but it was one of them. I believe it was Justice Morgan. Those are the kinds of lines and distinctions that are very difficult. The bright line test that Lord sets out is very easy. Was there a contract? Was there not a contract? If there was, economic loss rule applies. If there's not, economic loss rule does not apply. Chief Justice Beasley, I've got just under 2 minutes left. I think I'll stop there and hold the last couple of minute or so for rebuttal. Thank you very much.
Thank you. Mr. Hill.
Thank you, Chief Justice Beasley. May it please the court, I'm Martin Hill representing Trussway in this case. And Crescent, as has been discussed a moment ago, is appealing Judge Bledsoe's opinion holding that in the context of a commercial developer, owner of a property as a commercial developer who develops a commercial project, in this case 189 apartment units in 5 separate buildings, as a commercial project under the commercial construction rules under Mecklenburg County. It's a separate set of construction inspections and additional rules when it comes to commercial construction. When that developer, as in the case of Crescent, has a contract, a prime contract with a general contractor, in this case AP Atlantic, and has its bargain for remedy through that contract, then in that instance, it cannot also sue at the same time for tort, which is exactly what Crescent is doing in this case. And as has been mentioned a moment ago, there are some fact issues that Judge Bledsoe needs to sort out. And that is the subject actually of a separate opinion that Judge Bledsoe wrote approximately and published approximately a week before he published the opinion in this particular case that's on appeal. That 119-page opinion outlines a very complex set of contractual relationships between the parties. And essentially, that case is going to go to trial in November of this year, based on whatever those contractual expectations were, holding each person, each party, to whatever the contractual obligations were that they have, and giving each party to that contract the contractual rights that they had. Crescent, as Mr. Maida mentioned a moment ago, would actually like something more than the benefit of its bargain as expressed by that comprehensive prime contract and the various subcontracts. They would like to not be prevented from pursuing additional damages that they're contractually prohibited from pursuing. Crescent also would like to not be limited to the right to cure that was in the general contract, the prime contract between AP Atlantic and Crescent, and the right that was also in Madison's subcontract and in Trussway's subcontract, which is the right to cure, the right to repair or replace. That is in every contract. That has become an issue in the contract case, as alluded to in Judge Bledsoe's opinion in this case. And therefore, to avoid those limitations of liabilities and to avoid and prevent Trussway and the other subcontractors from having the rights that were part of that contractual relationship, Crescent in February of 2018, after pleadings were cut off, the deadlines had expired in the contract case, decided we're going to add a new claim and we're going to separately sue Trussway in a direct negligence action. Now, Crescent wanted everything to be in the same court, the same jury as they've expressed in their brief in this case. So they moved then to designate the negligence case as a complex business case so that they could get in the same court and then move to consolidate. In that process, Crescent did a designation that they filed stating that their case, their new case, the one that's now before you, is actually a case in contract. That's what their designation says. indeed, it is a contractual case. Their brief cites as the obligation for Trussway, the Trussway contract. The Trussway contract is in approximately page 222 to 232, I think, of the record. And within that contract, it's 10 pages. Two pages of that 10-page contract are Trussway's language. 8 pages of that contract are the specifications that Crescent issued that became incorporated by reference and actually was attached to and became the Trussway contract. So to the answer to some of the questions earlier, who is in the best position to contract for whatever it is that Crescent wanted? Crescent.
But before you move on from that, Mr. Hill, I had some discussion with Mr. Mehta about the exact role that your client played in this project. He repeatedly described Trussway as a designer / manufacturer, or use some similar terms. How would you describe the role played by your client in this case?
Trussway receives from Crescent a set of design specifications that provide, along with the architecture of Crescent, what the size of the trusses need to be and what the load resistance needs to be. In other words, how many pounds per square foot can it carry, those sorts of things. Those design specifications are provided to Trussway. Trussway then does do a design only for its product. It is not providing information for someone else to use on a project. It designs the truss to be able to hold the load that is required by Crescent's experts. And then after those designs are submitted through Madison up to the general contractor and then to Crescent through its architect and engineer that are approved by them, then Trussway manufactures those trusses and delivers them to the job site.
Do you dispute the accuracy of Mr. Mehta's characterization of your client as a designer manufacturer?
They design not the project, but they design their trusses to comply with the project specifications. So with that caveat, I would say I agree that there is a design aspect to it, but it is not of the project. It is only of Trussway's product. It is a tangible product that's sold.
Should the nature of the work performed by your client have any bearing on the extent to which it would be liable to Crescent and Tort?
Not in the context of a commercial building construction project, because the 8 pages that are referenced within the contract, as well as Trussway's 2 pages that it wrote, both refer to a standard called the TPI-1. Within that standard, it allocates responsibilities to the various parties at the construction site. And why that's so important is because Trussway is not at the job site, but it relies, every project in America that's built with wood trusses is going to have some damage to trusses. Some plates are going to pull loose, some wood is going to get damaged with forklift, dropping, mud, whatever might happen. And so that allocates the responsibilities of the parties as to how to construct those trusses, to install something called a strongback, for example, that stabilizes the trusses and shares the load as between trusses. So it's a comprehensive contract. And so in that context, you have to look at the contract, because while Mr. Mehta is correct, it does limit damages, and that's something that bothers Crescent. But in addition to limiting damages all the way up to the contractual relationships, the Trussway contract and TPI-1 establishes an allocation of responsibilities as to how the project is supposed to be built.
So why should it matter whether this is a complex commercial project as compared to the construction of a single residential facility for a private individual?
It's I think, a public policy finding over the years from courts across the country, including, I think, the courts in North Carolina, that, and as East River, I think, does a better job of explaining a lot of courts, the Supreme Court decision, if parties have the bargaining power, as it is presumed in a commercial context that they have that bargaining power, as for example here, Crescent wrote the specifications. It required whatever warranty, whatever obligations it wanted. That is the fundamental assumption upon which the economic loss rule is based. If parties don't have any bargaining power, if they're provided with only a contract of adhesion, something with totally one-sided provisions, just as this court cited in Oates, the Florida case, the Simmons case, it says, let's be realistic. The individual homeowner is buying a house. It's the largest investment he or she is likely to make. They are not sophisticated enough, and it's not just being sophisticated. You can be the smartest person in the world, and it doesn't matter. You don't have any bargaining power when you're buying an individual house. Oftentimes, you simply get it.
In Oates, the plaintiff was a subsequent purchaser. I want to make sure I understand what you're saying. Are you arguing that the economic loss rule does not apply at all in the residential building context?
No, not necessarily. I'm saying that is a major distinction. There are times that the economic loss rule should apply if the contract, if there's some provision, some opportunity for that individual homeowner to have a remedy. In those cases, the courts held, both in Oates and in Lord, that, and referencing the Simmons case, that individual homeowner had absolutely no remedy and had no opportunity to have a remedy.
Do you believe that Lord was correctly decided?
In the context of an individual homeowner, it was within the discretion, I think, of the courts in North Carolina, and although it is the Court of Appeals, to say we're going to provide some kind of remedy to the homeowner who has not only does not have a remedy, but had no opportunity to have a remedy.
So your argument is that Lord, we don't need to overrule it because Lord has no application to this case.
Lord specifically referred to Oates, and they referred to the Simmons cases dealing with an individual homeowner. Some courts in some states have taken a broader view of the economic loss rule and basically said it's caveat, it's beware when you buyer beware. I think in North Carolina, you've taken a more perhaps protectionist role and some courts have, of individual homeowners who have no opportunity to bargain. That is a separate issue from the issue here where we have specifications written by Crescent and Trussway, in order to be the contractor on this project to provide the trusses, had to accept all of those provisions and did accept all of those provisions and incorporated it by attaching 8 pages of specifications to its contract.
Are you saying that Lord is applicable, or are you saying it's distinguishable? I didn't quite hear a response directly to Judge Davis's question as to how we should be guided by Lord.
I think Lord has no application to the case of a commercial developer building a commercial project where he has a remedy based on the prime contract that was knowingly entered into and with relatively equal bargaining power. So the court could take a broader view of somehow modifying Lord, certainly, but it need not do that in this case, because in the context of a commercial developer who has a remedy, and in fact, that contract case is going to trial in November, subject to a few conditions, I suppose. In that case, they have a remedy. Crescent has exactly the remedy that it bargained for. And
go ahead. I'm sorry.
Well, that's very different than the case in Oates, where you talk about an individual homeowner who's a stranger to the entire relationship. Here, Crescent cannot be a stranger to the relationship. They're the ones that wrote the contract. They're the ones that wrote the specifications. If Crescent had wanted certain warranties, and actually their contract requires certain warranties of certain subcontractors, those warranties pass through. We disagree with the suggestion that there is no contractual warranty, but it's not necessarily dispositive of the issue as Judge Bledsoe.
What is the warranty? I've read the material in the briefs about the warranty. At least expressly, it appears to run from your client up to the next contractor up the chain and not to Crescent. How does Crescent have any warranty claim against your client?
Well, not dispositive of the issue. To answer your question, if you actually read the entire warranty, I think it started at the top. The first half of the warranty section talks about Trussway warranting its work. There is a provision in there.
Is it just, I mean, Mr. Hill, just, I apologize for interrupting you, but just want to make sure I'm following you. Is your argument then that somehow that language, which generally says that the Trussway warrants its work, is a global warranty that's available to anybody? Or is it just available to the other party to the contract in which warranty appears?
It is available to anybody. It has been utilized that way and implemented that way across the United States in every project. There is.
So you would concede that Crescent could file a case against Trussway directly on the basis of that warranty?
Crescent could have done that if they wanted to, and Trussway would have honored the warranty. And in fact, at the commencement of this case, actually before the litigation commenced, Crescent put demand on the general contractor, AP Atlantic, and by two letters that are referenced in the record, told AP Atlantic, its general contractor, to put Trussway and its carriers on notice because Crescent was pursuing its remedy through AP as the general contractor to pursue not only AP, but to demand that Trussway and the other subcontractors respond by showing up at the job site, inspecting it, putting their insurance carriers on notice. And so they believed that there was a duty of Trussway to respond. And in fact, Trussway did respond. That's really not disputed. So they did have a remedy. And if they didn't like that remedy, Crescent is the one who wrote the specifications. Crescent is the one who could have asked for whatever warranty they wanted, and Trussway would have built that into the price.
Crescent talks about Oaks as being a refinement, to use that term that was used in the brief of Crescent, a refinement of North Carolina State Ports Authority in terms of what you had talked about earlier. If this court wanted to take a more expansive view, how do you see that depiction of Oaks as being a refinement so as to perhaps bolster its position as compared to yours?
Well, Ports Authority didn't actually use the term because it was developing at the time of economic loss rule, but the concept was certainly stated by this court in Ports Authority. And in Ports Authority, this court issued 4 separate exceptions, but then also, and the exceptions were basically damage to the individual. If there's harm to an individual, no matter who it is, economic loss rule doesn't apply. Harm to property other than the subject of the contract. Willful conduct or some type of a bailment custodial relationship. But then in Ports Authority, the court said, well, there could be other exceptions. So I think it opened the door to, there might be a circumstance where the underlying logic behind the economic loss rule, which is the bargaining power to be able to assume that in a commercial business context, much as East River held a few years after Ports Authority and used the term economic loss rule, that the economic loss rule would not apply to something that was terribly unfair where nobody had the opportunity to bargain to get the remedy. So it is an additional exception, certainly, to the general rule of the economic loss rule to say that the individual homeowner who has had no opportunity to bargain for a remedy that has nothing really to do with the specifications, they're simply dumped upon them, that in those circumstances, it seems terribly unfair to not give them a remedy. And that was sort of citation to the Florida cases. So it certainly was within the contemplation of Port Authority that Oates might make an additional exception. This court did make that exception for the individual homeowner. Yes, and I think the logic was, as the court expressed, because the individual homeowner is making this large investment and is ill prepared or equipped to bargain for any kind of remedy. So without a remedy, it seems unfair. And so the notion, sort of the continuation of the demise of the privity paradigm, is that we will allow then those individual homeowners to bring an action in tort, and we will not allow the economic loss rule to prevent that. Now, some courts in some states, as has been briefed, take a pretty hard line on that and say, you you just need to be aware when you buy a product. And many of those cases are discussed in the brief.
Do you see the contract privity issue as being dispositive here?
I do not see the contract privity issues being dispositive because the issue of, first of all, privity is beginning to be less and less important as we move forward. It's over the years, last 30 years, and it is, or maybe 40, I'm getting older. And as privity has become less important, it's more about, are the courts going to protect people who need protection? And in this case, Crest is trying to say, well, we're just like the individual homeowner. We need protection. And yes, we had a bargain. Yes, we had a contract. Yes, we said we'd limit consequential damages. Yes, Trussway thought that it was going to have its damages limited. Yes, Trussway thought they were going to have the right to cure or repair or replace their trusses because that's what the contract says. But you know what? We don't like that. We're going to still sue for that. But in addition to that, we want to be able to pursue these additional damages. We want to deny Trussway the benefit of its bargain by having the right to repair or replace its trusses and to have the right to be assured that other subcontractors on the project are assuring that at the time that the project is closed up, that the trusses are in the condition they're supposed to be in. That's the
Sorry, I apologize for interrupting, but I just want to, on the point you were just making about Crescent having struck this bargain and limited consequential damages, what's your response to what I understand Crescent's argument to be, that at the time they negotiated this contract, Lord was the controlling appellate authority that said a case that did involve trusses and said that there was an action in tort for negligence for the for someone in Crescent's position. Well, so they were negotiating in the context of that being the law.
Well, the first suggestion would be is that actually Port's authority is the law, not Lord. Secondly, that Lord was a carve out for the individual homeowner. We understand in the construction industry that individual homeowners may have rights that you can't necessarily contract away their rights. But in the commercial context, if that is indeed what Crescent believed, then they committed a fraud on Trussway when they issued a specification and said, this is your contractual obligation, and you have a right to repair or replace trusses. You have a right to limit your damages. No one at the time thought that the contract is irrelevant. If the contract had been irrelevant, then there's no point in attaching 8 pages of specifications from Crescent. You would have just had a one-sided contract. It doesn't really make a difference what the trust is, what the contract says, if you believe that line of theory. I think there is a general understanding in construction across the country that when you're talking about individual homeowners, they may well have rights that you cannot necessarily issue contracts that are completely unfair. But in the commercial context, the commercial contracting parties, as East River did a very good job of explaining, have a right to expect that their contracts will be upheld. And so this was a commercial contract and there would be no indication. And in fact, for 3 years, Crescent didn't think they had any claim for negligence. They pursued the contract action. It was only later when they didn't like the results of their remedy and they didn't like or the bargain that they had struck that they decided, you know what, we might as well also ask for these additional damages. So for 3 years, they thought the same thing we thought, which is this is all going to be based on contract.
If Trussway had written the entire contract, hypothetically, would your argument be any different?
If Trussway had written the entire contract in the sense that it did not incorporate by reference the specifications for this particular project, it is.
Well, if Trussway had just sent over a contract and Crescent had signed off on it without any substantive changes on its part.
If Trussway had sent, no, but we're still in the context of commercial contracting parties. So if someone sends a contract between commercial contracting parties, it is my obligation as a lawyer for a commercial contracting party to read the contract and say, is that what my client wants? And the same is true on both sides. So it might well be that Trussway could have written the contract and sent it to Crescent, and Crescent said, yep, that's what we want. Okay, well then that's what you're going to get. Nothing more, nothing less.
So the point is, you're saying in the commercial context, both sides do have bargaining power, unlike the residential context.
That is the key distinction that Judge Bledsoe made. That is the key distinction that many, many courts have made. And I think that's the key distinction that this court made in Oates and the Court of Appeals made in Lord. And certainly the reference to Simmons and the Ford line of cases was along those same lines.
If I understood Mr. Meadows' argument earlier, he tended to suggest that that's not at least I understood him to suggest that that's not necessarily a particularly valid basis to distinguish the two different rules, because you can have on the one hand very sophisticated individual homeowners. I think his example was Michael Jordan. Then on the other hand, you can have relatively unsophisticated business entities on the other hand. What would be your response to that argument?
I agree that the use of the term sophisticated, which most courts do, and I have been guilty of as well, refers to perhaps a level of competence that's really not the key issue. The key, because I can be competent and clients send me notes, promissory notes to borrow money to buy a house. And if it's from a commercial bank and they're just going to buy a house, I have no bargaining power, right? Because they're not going to change the note just because of me. So in the context of a commercial construction project, it really is more to do with, do you have the ability to bargain, and does the contract actually reflect the meeting of the minds of the parties? And if so, we're going to hold them to that. The good thing about the demarcation between commercial and residential is even in Mecklenburg County, there's a different set of inspectors. There's a different set of regulations. So it's easy to see the difference between commercial construction, where people should be held to the benefit of their bargain. There are large amounts of money at stake versus residential construction. And if you get into simply looking at whether somebody's sophisticated, you could have somebody with 5 degrees in engineering, law, and everything else. And if they're still an individual homeowner, they may not have had the opportunity to bargain. So that's, I think it was the distinction in the case law. And it's an easy way to make the distinction. And in this case, the court doesn't need to go too far down that road, other than to simply say, when you have a commercial developer building a commercial project and they have a contractual remedy, which is precisely the benefit of the bargain that both sides have, they have to follow that remedy, and they cannot, in addition to that, avoid their obligations and avoid the rights of the other participants to that contract by separately suing in tort. And that's exactly what's happened in this case. Crescent wants 2 bites at the same apple, and the second bite, they want some additional damages that they're not entitled to under the benefit of the bargain, and they want to be able to deny Trussway the right to rely on other subcontractors who, by their contract in TPI 1, are allocated to, for example, Madison has a duty to inspect, and if they see a problem with the truss, they are to notify Trussway before they close up the building. This is a contractual provision that's designed to avoid exactly these types of situations, is to impose that duty. I don't want to get into the facts of that, because the facts are going to come out in the contract case that's going to trial in November. But that's what Crescent is trying to deny to Trussway by circumventing the contractual relationships. And I would, so I only have a minute and a half left, I see, just suggest also that there is a very, very substantial distinction between what Trussway did in terms of design and what the cases that are now being raised for the first time on appeal, which I think under your appellate rule 10 Crescent has now changed, and for the first time on this appeal is saying, oh, our real exception is not only that we want to be just like an individual homeowner, but we also want to say that Trussway is a design engineer. Trussway only designed the trusses. In the other cases that are cited, particularly the Davidson case, they're providing information. That architect engineer who did the soil test is providing information that somebody else is relying on. The same thing in the leasing case, where they provided, a lawyer provided bad information about a lien search. In both of those cases, somebody else was relying on that information. So the court shouldn't consider it because it's a violation of Rule 10. And also those cases are completely irrelevant in this context. We think that Judge Bledsoe has first a 119-page opinion in the contract case and a 40-page opinion in this case, that he decided it correctly, and we would urge the court to affirm.
Thank you, Mr. Hill. Rebuttal, Mr. Mehta.
Thank you, Madam Chief Justice. Let me just take very briefly that last point that Mr. Hill was talking about. And he's correct that the position of the Trussway in this design function is not exactly the same as a project architect. However, in this case, the information supplied was from Trussway as the designer to Trussway as the manufacturer. And that information ended up in a truss that failed. And that's the point that makes the Davidson and Jones line of cases exactly the same as our case.
Mr. Mehta, do you concede that Trussway did draft some portions of the contract?
Well, yes, I was about to say.
I'm sorry, Crescent, I misspoke. That Crescent drafted some portions of the contract.
Mr. Hill repeatedly said there are 8 pages of specs and 2 pages of Trussway's stuff. Well, the 2 pages of Trussway's stuff include the warranty that Mr. Hill says extends all the way to Crescent. You can read that warranty as Justice Irvin did. It does not do that.
I'm sorry, my question was, did Crescent draft any portion of the contract?
Of the entire contract or the Trussway contract?
The Trussway contract.
They drafted specifications that were then attached to the contract. That's all they did. So the specifications are the design basis. The contract itself, the warranty piece of the contract is Trussway's. And what Trussway's trying to do here is hide behind the economic loss rule to say, oh, you can't have a negligence claim, but also say, here's the warranty.
But Crescent have insisted on a stronger warranty provision?
Crescent could have insisted on one.
Mr. Mehta, actually, your time is up.
Will I get to answer that question or not?
You can have a couple seconds to answer that question.
The answer is, of course, Crescent could do that, but also Trussway could have made it clear. And it was Trussway's warranty, and it failed to do so. And its failure to do so means it shouldn't get summary judgment on that point. Thank you.
Thank you, Mr. Mehta. Thank you to all counsel. We appreciate you all being here today. Thank you.
Thank you.
All right. Thank you all. If I could go ahead and log off, and members of the court, if you could log on to the next session. Thank you.